For most people thinking about estate planning, it all comes down to one big decision. Should I use a will or should I set up a living trust? And it's not always a clear cut answer. I've seen families who chose a will and had no major issues. I've also seen families lose months of time and thousands of dollars at probate because a simple plan wasn't in place. So, in this video, I want to talk you through both options, what a will actually does, what a living trust does differently, and how to decide what's right for you and your family. Quick note before we begin, this isn't legal advice, it's for educational purposes only. Every family situation is different, so be sure to talk to a qualified estate planning attorney about your specific needs. My name is Jason Gray, and me and my team at Pinnacle Estate Planning help families, homeowners, and business owners across Washington, Idaho, and South Dakota protect what they built from estate taxes, probate, incapacity, Medicaid threats, with what we believe is the most effective estate plan available. Now, let's get into it. What a will does and doesn't do. A will is often the first thing people think of when it comes to estate planning. And yes, it's an important legal document. Lets you spell out who gets what after you pass away. You can name your spouse, your children, even leave gifts to specific people or charities. You can also include provisions to set up a trust for young or financially immature heirs, what's called a testamentary trust, because it's created through your will after you're gone. But here's the catch, and it's a big one: having a will does not avoid probate. A lot of people assume that once they've written a will, everything is handled smoothly and privately. Unfortunately, that's not how it works. A will is essentially a set of instructions to the court. It still has to go through a legal process called probate, and that's where the headaches begin. Probate is the court supervised process that happens after someone dies. It involves validating the will, making sure it's legally enforceable, identifying and inventorying all of your assets, notifying creditors, settling any debts, and finally distributing what's left to the heirs named in the will. It's slow, it's public, and it's expensive. And here's what many people don't realize: if your assets are in your name alone when you die, your home, rental property, checking and savings accounts, investments, they're all frozen. Your family can't sell them, they can't transfer them, they can't even access your bank accounts to cover funeral expenses without court approval. That's why the person you named in your will, the executor, has to hire an attorney, file paperwork with the court, and navigate what's often a 12 to 24-month legal process. Even in Washington state, where probate is somewhat more efficient than some states like California or New York, you're still looking at potentially 4 to 7% of the gross estate going to fees and costs to get through that probate process. So let's break that down. If you own a home worth about $600,000 and it's still in your name when you pass away, and there's a $400,000 mortgage, your estate might be billed somewhere in the neighborhood of $24,000 to $42,000 in probate costs, because that probate, the complexity of it is going to be tied to that value of the assets there. And that's just one property. If we add in a second home, retirement accounts, investment portfolios, or a business, suddenly your family is staring down a legal process that could easily cost tens of thousands of dollars just to get what's already theirs. On top of the money, there's the emotional stress and the delay when your family's already grieving and now they're dealing with court hearings, legal filings, and paperwork. So, yes, a will give you control over who gets what, but it doesn't protect your family from the court system. What a living trust does differently. Now, let's compare that to a revocable living trust. A living trust is also a legal document, but it's more powerful. It lets you control what happens to your assets if you're incapacitated, choose exactly how and when your heirs receive their inheritance, avoid probate completely for any assets titled in the name of your trust. Here's how it works: you create a trust and transfer your major assets into it while you're alive, like your home, your rental properties, your investment accounts. You're still in charge of everything. You can buy, sell, refinance, move money around, but now those assets are legally owned by your trust. If something happens to you, say you're hospitalized or pass away, your successor trustee steps in and follows your instructions. No court, no delays, no frozen accounts. And since the assets are already in your trust, there's no probate. It's private, fast, and much easier on your loved ones. Why do families choose one or the other? So why do still some families still go with a will? In my experience, some people just say that they don't understand trusts or they think that trusts are just for multimillionaires, but that's just not the case. So which one is right for you? The bottom line is if you're fine with probate and your estate is simple, a will might be enough. But if you want to avoid any potential delays, court costs, public drama, especially if you have a home, business, kids, a living trust could be a game changer. And if you're married, setting up a trust now can help you avoid two probates instead of one. Either way, it just starts with a conversation. If this video sparked any questions or if you're wondering which path is right for your family, I invite you to schedule a time to talk with our team. We'll walk you through your options, explain what makes sense based on your goals, and help put a plan in place that protects what matters. Just click the link below or go to lawpinnacle.com to schedule a call. If you found this helpful, we've got plenty more videos on our channel. In fact, YouTube thinks the next one you should watch is right here.